If you get hurt at work, you can't bring a personal injury lawsuit against your employer. And believe it or not, that's one of the best deals working people ever won. My name is Jacob Candelaria. I'm on your side. This is the first of a series on workers' compensation, what most of us call workers' comp. And in the next 5 minutes, I'm going to show you the deal you have and the nightmare it replaced, because you can't see the value of what you've got until you've seen what working people used to get. So let's go back about 100 years. Back then, if you got hurt on the job, you had exactly one option: sue your employer and prove the injury was their fault. And waiting for you in that courtroom were the legal defenses so brutal that lawyers came to call them the unholy trinity. Let me make it real. In 1842, a railroad engineer named Nicholas Farwell lost his hand when a co-worker threw the wrong switch. He sued, and the court told him, because a co-worker caused it, not the boss himself, you get nothing. That was the first sister, the fellow servant rule. And on the factory floor or rail line, almost every injury involves a co-worker. So that one rule closed the courthouse door on most cases all by itself. The second sister was assumption of risk. Take a dangerous job, and the law said you accepted its dangers. The third, contributory negligence, was the cruelest. If you were even 1% at fault for your own injury, you recovered nothing. Not less, nothing. Put these three sisters together, and here's what you had. A worker could be maimed on the job through almost no fault of their own and walk out of court with nothing and a mountain of medical bills. For a long time, that was just how it worked. So about 100 years ago, workers, employers, and the states struck a new deal. We call it work comp, the grand bargain. And it works like a trade. Both sides give up something and get something. Here's what injured workers give up. They give up the right to take their employers to district court to assert civil law claims for damages in front of a jury. And that can include damages for emotional distress, pain and suffering, and punitive damages. But here's what they get, and it's a lot. Under work comp systems, injured workers no longer have to prove fault. Let me say that again. You don't have to prove fault, and that's at the heart of the whole thing. You don't have to prove your employer did anything wrong that caused your accident. You just have to show that the accident and its injuries happened at work, arose out of your employment. Now, what about the three sisters? They're gone. They can't be used against you in workers' comp. Now, in exchange, the system pays for medical treatment, replaces part of lost wages, and can provide additional money benefits for permanent injuries. Faster, more certain, no fault to prove. That's injured workers' side of the deal. Now, what did employers get? A limit on their liability. Lawyers call that the exclusive remedy. Employers pay into the system, usually through insurance, and in most cases, they can't be sued in court for a worker's workplace injury. No jury, no runaway verdicts. Predictability. And there's a third winner who never got to sign that deal. All of us. Because a hurt worker who gets nothing falls into public assistance. Work comp is built to get injured workers treated and back on their feet and back to work, instead of leaving their family and the injured worker to fall through the cracks or become dependent on public welfare. Now, two quick things you need to know. First, work comp is state law. Each state built its own system and its own rules and deadlines. So the details of where you live may look different from one state over. And second, your claim stays in the state courts. Congress said so directly. These cases cannot be yanked or removed to federal court, and that protects injured workers, in my opinion. One last thing, and it's something I'll come back to, is this idea of exclusive remedy, which says that you can't say sue your employer in district court. That rule is not absolute. An injured worker can step outside of work comp entirely and sue their employer in district court to a jury for common law claims for damages under certain limited circumstances, and that's what we'll talk about in the next episode. Now, this series is going to get practical. What to do in the first hours after you're hurt, the deadlines that can quietly kill a good claim, and how to stand up for yourself when the system pushes back or denies you. My goal is simple, that you and the people you love know what to do after a work injury before it ever happens. One important thing, and I'll say it every time, this is education, not legal advice, and it doesn't make me your lawyer. Because work comp is state-specific, and the rules change from place to place. So for your situation, talk to a work comp attorney where you live. I'm giving you the general roadmap. A local lawyer will give you the precise directions. The law was made for everyone. Most people just don't know it yet. Now you're starting to. I'm Jacob Candelaria. I'm on your side, and I'll see you on the next one.